Good afternoon, everybody. My name is Abhitya Ori, and I'm a faculty of Law and Governance in Jyoti Vidyapeeth University, Jaipur. So the topic that we're going to cover today is contingent contracts. Okay. So contingent, in literal terms, means to happen or not happen. इसका मतलब होता है कि या तो कोई चीज होगी या कोई चीज नहीं होगी. द प्रोबेबिलिटी और द स्पेक्यूलेशन ऑफ समथिंग हैपनिंग और समथिंग नॉट हैपनिंग. So like we can see from the literal meaning, contingent contracts are those contracts which are formed on the basis of an event happening or not happening. For example, if A tells B that if you complete this task, I will give you within 2 hours. For sake, I'll give you 50,000 rupees. So there is a contingency of something happening or not happening. So this is known as a contingent contract. We can also call it conditional contract. That means that the fulfillment of this contract is based on a condition. Only when that particular condition is fulfilled and completed, only then can we perform this contract or get this contract performed or enforced. So now this is covered under section 31 to section 35 of the Indian Contracts Act. So the section 31 of the Indian Contract Act talks about contingent contract and exactly says what I've taught you right now, that what are contingent contracts. Contingent contracts are the contracts that are enforceable on the happening or not happening of an event. Okay. Section 32. We'll talk about section 32. Section 32 of this contract says that whenever a contract is based on an happening of an event. For example, A tells B that if you get married to C, I will give you 10 lakh rupees. So that is the happening of an event. So this contract can be enforced only when that particular event has happened or occurred. If at any point of time that event is deemed to become impossible, here the contract becomes void. Similarly, section 33 talks about the not happening of an event. The not happening of an event. In this case, it is important that a particular event does not happen. Now the happening of an event we can judge that अभी तक हुआ है या नहीं हुआ है. अगर हो गया है तो this is enforceable, अगर नहीं हुआ है this is not enforceable. Now how do we judge the not happening of an event? Because it might not have happened right now, but it can happen tomorrow or day after or maybe after 2 months. So the judgment in this case becomes a little tricky. So here the not happening of an event is judged by the impossibility of that event. Okay, so it is said that if an event is deemed impossible, that is the not happening of that event. So when an event is impossible, we can get this contract enforced. Okay, section 34. This talks about impossibility as such. This means that if a contract is enforceable on the happening of an event, but that event seems impossible now, then the contract is void. For example, A promised to B that he will pay him 50,000 rupees if he marries C, but A married D. Per se an impossibility, hence the contract is enforceable. Or C dies. Again, the contract is rendered impossible and hence this contract is not enforceable. So somehow section 32 and section 34 go hand in hand. And the last section for this is section 35. Now in situations where the event is not impossible or will never be impossible, But we have to see the not happening of an event. What we do is we fix a particular time that if something does not happen or happens till 2 months or 3 months, only then can this contract be enforceable, otherwise it will not be enforceable. So this is all for contingent contracts. These are the major concepts in contingent contracts. The next thing we'll cover in the next class. Thank you.